Hello everyone, good day for all. Now, after a gap of 4 months, I am coming again with the subjects of 5th semester. The first subject is Civil Procedure Code, the exam topics. I have mentioned the questions. Let us go into the subject. Lawsuit. The term suit is not defined under the CPC, but by various decisions, it can be said that suit ordinarily means a civil proceedings instituted by presentation of a plaint. Civil suit is the institution of litigation for enforcement of civil rights. A suit is resulted into decree. Without suit, there cannot be a decree. Essentials of suit. There are four essentials of a suit. Name of the parties, causes of action. Coming to name of the parties, there must be two opposing parties. In a suit, there must be at least two parties, the plaintiff and the defendant. There is no limitation with regards to the number on each side. Cause of actions. It is the set of facts or circumstances that a plaintiff is required to prove. A person is party to a suit if there is a cause of action against him. Legally, the cause of action means every fact which is necessary for plaintiffs to be proved with a view to obtain a decree in his favor. The cause of action means all essential facts constituting the right and its infringement. Every plaintiff must disclose a cause of action. If not, it is the duty of the court to reject the plaint. The subject matter. There must be a subject matter with what respect or aspect the civil dispute is. Relief claimed by the plaintiff. No court will give relief unless relief is specifically claimed by the party. Relief is of two types, specific relief and alternative relief. There are various stages of civil suit. There is first institution of suit or commencement of suit by the plaintiff, service of summons to the defendant, a written statement from the defendant, first hearing and framing of issues in the court in front of the judge, discovery, production of evidence and final hearing, arguments, judgment, preparation of decree and execution of decree. Coming to plaint and drafting. A plaint is a legal document that contains the concept of any civil suit which shows the plaintiff's claim after filing suit. The plaint is the first step of the plaintiff in the form of legal document for the commencement of suit, and it shows what a plaintiff wants from that suit. The procedure of drafting, filing and rejection of the plaint is defined under Order 7 of CPC. In Order 7 of CPC, there are many different rules which deal with different constituents of plaint. Rule 1 to 8 deal with the particulars of the plaint. Rule 9 deals with the how the plaint will be admitted. Rule 10 to 10b takes about the return of plaint and the appearance of parties. Rule 11 to 13 deal with the rejection of plaint and in which circumstances the plaint can be rejected. Order 7, Rule 1, which states that if the following particulars are not mentioned in the plaint, then the plaint will be rejected. The name of the court in which the suit is brought, the names, place, description of place of residence of the plaintiff. Names, place, description of the place of residence of the defendant. A statement is mentioned if the plaintiff is minor or is of unsound mind. Facts constituting the cause of action and when it arose. Facts showing that the court has the jurisdiction to try the matter. The relief which the plaintiff wants to claim. Whether the plaintiff has allowed a set-off or relinquished a portion of his claim, the amount so allowed or relinquished, and a statement of the value of the subject matter of the suit for the purpose of jurisdiction and the court fees so far as the case admits. Where the suit is for the recovery of money, the precise amount is to be mentioned that is claimed. Where the suit is for accounts or mesne profits or for movables in the possession of the defendant or for debts which cannot be determined the appropriate amount or value thereof. where the subject matter of the suit is immovable property, description of the property sufficient to identify it, example boundaries, survey numbers, etc. Where the plaintiff files a suit in a representative capacity, the facts showing that the plaintiff has an actual existing interest in the subject matter and he has taken steps that may be necessary to enable him to file such suit. The interest and liability of the defendant in the subject matter of the suit, where the suit is time barred, the ground upon which the exemption from the law of limitation is claimed. Coming to drafting of plaint. From the above particulars, the plaint should be drafted in a particular form. Thus, the plaint can be divided into three parts: head and title, body of plaint, the relief claimed. Coming to head and title, where the name of the court should be as a heading. The name of the court should be written on the plaint as the heading. The name of the court is sufficient. For example, in the court of the district judge Sirsa, the parties to the suit, where when we talk about the parties to suit, there must be two parties in every suit, namely the plaintiff and the defendant. However, there may be more than one plaintiff and more than one defendant. All particulars of the parties, such as name, residence, father's name, age, etc., which are necessary to identify the parties, must be stated in the plaint. In the case of minors, a minor cannot be sued or be sued if one of the parties is a minor or of unsound mind. It will have to be mentioned in the cause title. Title of the suit. The title of the suit contains the reasons for approaching the court and the jurisdiction before which the plaint is initiated. Body of the plaint. It is the body of the plaint wherein the plaintiff describes his or her concerns in an elaborative manner that should be divided into short paragraphs which contain one fact. The body of the plaint is divided into two parts which are as follows. Formal part. This formal part contains the following essentials: a statement regarding the date of cause of action. It is necessary for every plaint to contain the date when the cause of action arose. The primary objective behind this is to determine the period of limitation. The plaint must state all facts showing how the court has pecuniary and territorial jurisdiction over the subject matter of the suit. The value of subject matter of the suit must be stated properly for the purpose of the pecuniary jurisdictions of the court and court fees. Statement regarding minority, the representative character of the plaintiff, the reasons why the plaintiff wants to claim exemptions under the law if the suit is initiated after the period of limitation. The next is substantial portion. In this portion, the plaint must contain all the necessary and vital facts which constitute the suit. The plaintiff wishes to pursue a cause of action on any other grounds must be duly mentioned. It should be shown that the plaint It should be shown in the plaint that the defendant is interested in the subject matter and therefore must be called upon by the court. Where defendants are more than one and if the liability is not joint, then the individual liability of each and every defendant must be shown separately. In the same way, if there are more than one plaintiff and their cause of action is not joint, then too the same has to be mentioned separately. Relief. Every plaint must state specifically the relief claimed by the plaintiff, either simply or in the alternative. It is the last part of the plaint. It must be claimed properly and accurately. Every plaint must state specifically the kind of relief asked for, be it in the form of damages, specific performance or injunction, or damages of any other kind. This must be done with utmost carefulness because the claims in the plaint cannot be backed by oral pleadings. Signature and verification. The signature of the plaintiff is put at the end of the plaint. In case the plaintiff is not present due to any legitimate reason, then the signature of the authorized representative would suffice. The plaint should also be duly verified by the plaintiff. Where the plaintiff is unable to do so, his or her representative may do the same after informing the court. The signature of the plaintiff or verifier along with the date and the place at the end of the plaint is essential. The verification can only be done before a competent court or in front of an oath commissioner. This is the format of plaint. Coming to frame of suit under Order 2. Order 2 of the Civil Procedure Code deal with the framing of suit. It lays down the rules as to how the suit should be framed. While drafting a plaint, the plaintiff must draft his plaint in such a way that it includes all the important assertions and the claims that the plaintiff wishes to put before the court. It is the plaint of the plaintiff which speaks in court before the judge. The plaint should be such that which can take a case towards the conclusion for final decision. All the subject matter in dispute must be decided at once. The suit to include whole claim. This is discussed under Order 2 rule. The plaintiff in his plaint must include the whole claim which he wishes to seek from the court. For the purpose of bringing the suit within the jurisdiction of any court, the plaintiff may relinquish or abandon any part of the claim. Example, A files a suit against B for recovery of money. The amount to be recovered is 3 crores. For the purpose of falling in the pecuniary jurisdiction of the district court, A files a suit for recovery of money of 2 crores only. Here, A has relinquished his part of the claim of 1 crore for the purpose of bringing suit within the pecuniary jurisdiction of the district court. As the pecuniary limits of Delhi district court is up to 2 crores. If he would have to make the whole of his claim, then the jurisdiction would have fallen under the Delhi High Court. Relinquished part of claim, that is voluntarily giving up the part of the claim. Once a relinquishment is always a relinquishment. If the plaintiff omits to assert his claim or intentionally relinquishes any part of the claim, then he loses the right to sue for it afterwards. Later on, the plaintiff can't assert for the claim he has relinquished. The court will not entertain the claim. With the reference to the above example mentioned, the claim which the plaintiff relinquished in order to bring the suit within the pecuniary jurisdiction of the Delhi District Court can't be raised subsequently in a different suit. If the plaintiff has omitted or intentionally relinquished his portion of the claim, then he can't sue for it afterwards. Omission to sue for one of several reliefs. If the plaintiff is entitled to more than one relief for same cause of action, he must sue for all such reliefs. If he omits to sue for any one of several reliefs, then he can't bring another suit for claiming such relief. Exception to the above rule. If the plaintiff takes the leave of the court for relinquishing any of his relief, then he may sue for such relief afterwards. With the leave of the court, Order 2, Rule 2 does not bar such relief, but if the leave is not taken from the court, then there will be a bar under Order 2, Rule 2 of CPC. Example, A is a landlord and B is a tenant. B has not paid rent for the last 3 years and is in a wrongful possession of the property. A files a suit against B for the possession of the property. A, in a subsequent suit, claims for the arrears of the rent against B. The subsequent suit is barred under Order 2, Rule 2 of the Civil Procedure Code. The object of Order 2, Rule 2 is to prevent the multiplicity of cases. Already the code is burdened with lakhs of cases. The purpose behind this rule is that the defendant should not be put in trouble twice for the same cause of action. The matter should be decided at once on merits. Multiple claims raise confusion and destroy the precious time of the court. Hence, the significance of Order 2, Rule 2 is appreciated in the framing of a suit. Case law on Order 2 is Muhammad Khalil Khan versus Muhammad Mia Ali. The Privy Council held that if the relief claimed in a new suit is based upon the same cause of action as of former suit, then it shall attract the bar under Order 2, Rule 2. If the relief claimed is distinct from the former cause of action, then it will not be barred under Order 2, Rule 2 of the CPC. Let us see about res judicata. The origin of the doctrine of res judicata is one of the oldest doctrines in the history of the world. Res judicata is as old as the law itself. Res judicata pro veritate acciputur is a Latin maxim for the doctrine of res judicata. The roots of res judicata can be found in the various ancient legal systems. Indian legal system adopted the doctrine of res judicata from the common law. The principle of res judicata was included in section 11 of CPC. Meaning of res judicata is res means subject matter, judicata means adjudged or decided, and together it means a matter adjudged or a matter decided. In simple words, the thing has been judged by the court. The issue before a court has already been decided by another court and between the same parties. Hence, the court will dismiss the case as it has been decided by another court. Res judicata applies to both civil and criminal legal systems. Example, A sued B as he didn't pay the rent. B pleaded for the leasing of the rent on the ground as the area of the land was less than the mentioned area on the lease. The court found that the area was greater than shown in the lease. The area was excess and the principles of res judicata will not be applied. The principle of res judicata is seeks to promote the fair administration of justice and honesty and to prevent the law from abuse. The principle of res judicata applies when the litigant attempts to file a subsequent lawsuit on the same matter after having received a judgment in a previous case involving the same parties. In many jurisdictions, this applies not only to the specific claims made in the first case, but also to claims that could have been made during the same case. Essentials of res judicata under section 11 CPC. Before granting a decree of res judicata, following conditions should be satisfied. First, there must be two suits, one former suit and the other subsequent suit. The parties of the former and subsequent suit are the parties under whom they or any of them claim should be the same. The subject matter of subsequent suit should be identical or related to the former suit either actually or constructively. The case must be finally decided between the parties. The former suit should be decided by the court of competent jurisdictions. The parties in the former as well as subsequent suit must have litigated under the same title. Constructive res judicata. The rule of constructive res judicata is an artificial form of res judicata. It provides that if a plea has been taken by a party in the proceeding between him and the defendant, he will not be permitted to take pleas against the same party in the following proceeding with reference to same matter. It is opposed to public policies on which the principle of res judicata is based. The rule of constructive res judicata helps in raising the bar. Coming to case laws on res judicata. The state of Uttar Pradesh versus Nawab Hussain. M was a sub-inspector and was dismissed from the service by DIG. He challenged the order of dismissal by filing a writ petition in the High Court. He said that he did not get a reasonable opportunity of being heard before the passing of the order. However, the argument was negative and the petition was dismissed. He again filed a petition on the ground that he was appointed by the IGP and had no power to dismiss him. The defendant argued that the suit was barred by constructive res judicata. However, the trial court, the first appearance appellate court as well as the High Court held that the suit was not barred by the doctrine of res judicata. The Supreme Court held that the suit was barred by constructive res judicata as the plea was within the knowledge of the plaintiff, M, and he could have taken this argument in his earlier suit. Devilal Modi versus sales tax officer. In the leading case of the Devilal Modi versus STO, B challenged the validity of an order of assessment under Article 226. The petition was dismissed on the basis of merits. The Supreme Court also dismissed the appeal that was made against the order on the basis of merits. B again filed another writ petition in the same High Court against the same order of assessment. This time the petition was dismissed by the High Court. The Supreme Court held that the petition was barred by the principle of res judicata. Foreign judgments. According to the Civil Procedure Code 1908, foreign courts means a court situated outside India and not established or continued by the authority of central government. And foreign judgments means the judgment of a foreign court. The term foreign judgment has been defined in section 2 under 6 of the Civil Procedure Code as a judgment of a foreign court. The judgment of foreign court is enforced on the principle that where a court of the competent jurisdiction has adjudicated upon a claim, a legal obligation arises to satisfy the claim. Does the foreign judgments be conclusive? In a civil procedure code, it is mentioned that the foreign judgment is conclusive, but there are certain circumstances in which it does not amount to be conclusive. A foreign judgment is not conclusive in the following 6 circumstances, which are mentioned in the section 13 of the code, where a court of competent jurisdiction has not pronounced the judgment, unless it was granted on the merits of the case, where and on the face of the trial it seems to be based on an erroneous interpretation of foreign law or on a failure to accept the law of India in situation where the law is valid, where the natural justice is contrary to the courts in which the judgment was received, where it was acquired by fraud, where it sustains a claim founded on the breach of any law in force in India. Enforcement of foreign judgment. In India, a foreign judgment can be enforced in the following methods: by instituting a suit on such foreign judgment. From the date of judgment, 3 years have been given to file a suit. From instituting execution proceedings, the said provision states that if a certified copy of decree has been filed in a district court by either of the superior courts of any reciprocal jurisdiction, the decree can be enforced in India as if it had been passed by the district court. Coming to case law, Shankaran Govindan versus Lakshmi Bharati, the Supreme Court held that it is a well-established proposition in private international law that unless a foreign court has international jurisdiction, a judgment that's delivered by that court will not be recognized or enforced in India. In case Satya versus Teja Singh, the Supreme Court of India held that it is understood that foreign law and the foreign judgment would not offend against the Indian public policy. Coming to jurisdiction and place of suing. Jurisdiction is derived from the Latin words juris, which means law, and dicere, which means to speak. The jurisdiction refers to the power of the court to take the cognizance of an offence and to determine the cause of action. Judicial forum must have an authority to adjudicate on the matter. The judicial forum must have jurisdiction to deal with the matter. Each court has different jurisdiction. Section 9 to 21 cover all aspects relating to fundamental jurisdiction. Section 9. As per Section 9, civil courts have jurisdiction to deal with all matters of civil nature that if it is not expressly or impliedly barred. In case of PMA Metropolitan versus Maranmar Marthamma, the Supreme Court observed that the phrases used in Section 9 has a positive and negative meaning. The earlier part has a wider sense and it covers all matters of civil nature. On the other hand, the latter part has a wider sense as it excludes the matter which is impliedly or explicitly barred. The two explanations mentioned in the Section 9 expresses the legislative intentions. It cast an obligation on the court to exercise the jurisdiction for the enforcement of private rights. No court is at its discretion to refuse the matter which falls under this section. It is mandatory to take the cognizance of matter because the word shall is used, which means that it is a mandatory section. Types of jurisdictions and place of suing. A matter can only be tried by a court if it operates within all three kinds of jurisdiction. When a court with a faulty jurisdiction tries the case, it will be termed as an irregular exercise of jurisdiction or lack of jurisdiction, which may turn the decision void or voidable depending upon the situations. Section 15 to 20 explicitly talks about the types of jurisdiction. Section 21 talks about the judgment passed by a court with no jurisdiction. The jurisdiction in CPC is of three types to determine the place of suing: pecuniary jurisdiction, territorial jurisdiction, subject matter jurisdictions. Coming to pecuniary jurisdiction, which are discussed under section 15. Every suit shall be instituted in the court of lowest grade competent to try it. The word competent denotes that the court must have the power to hear the case with regards to pecuniary jurisdiction. The court of lowest grade, who has a jurisdiction with regards to pecuniary value, shall deal with the case at first instance. The value to decide on jurisdiction for filing a suit is generally done by the plaintiff. However, if the valuation of the plaintiff is prima facie incorrect, then the court evaluates and directs the party to approach the right forum. Territorial jurisdiction is discussed under section 16 to 20. The territorial jurisdiction divides the jurisdiction of courts on a horizontal basis. All courts that have power to take cognizance of a case have the same powers, and no court is considered above the other. Territorial jurisdiction in CPC is further divided into suits related to immovable property, suits related to movable property, and other suits, which are discussed under section 20. Other suits to be instituted where the defendants reside or cause of action arises. Coming to subject matter jurisdiction, different courts are empowered to decide different types of suits. Certain suits have no jurisdiction to entertain certain kind of suits. Example, the court of civil judge cannot pass a decree in suits for testamentary succession, divorce cases, probate proceedings, insolvency matters, like that. This is known as subject matter jurisdiction, where only if a court has jurisdiction over a certain class of cases can a case from such a class be approached. Original or appellate jurisdiction. In the exercise of original jurisdiction, a court entertains original suits. Municipal courts and courts of small cases have only original jurisdiction. Court of civil judge, district judge, and high courts exercise both original and appellate jurisdiction by entertaining original suits or writs and appeals. Examples of for place of suing: A residing in Delhi beats B in Calcutta. B may sue A either in Calcutta or in Delhi. A residing in Delhi publishes in Calcutta statements defamatory of B. B may sue A either in Calcutta or in Delhi. In case of Karan Singh versus Chaman Paswar, when the court commits an error in entertaining the suit with regard to pecuniary or territorial jurisdiction, then the decision given by such court will not be void but will be considered as an illegal exercise of jurisdiction. In case of State of AP versus Manjeti Lakshmikant Rao, the court held that for the purpose of constructing the test to determine the exclusion of civil court, it is necessary to look into the intent of legislature to exclude the jurisdiction. It means that the test is done to determine whether there is any reason for the exclusion of jurisdiction, and if there is any reason, to further find out whether the just reason is justified or not. Coming to suits of civil nature. A common man might not be able to distinguish much and also does not know the different types of specialized courts established in India for different matters. For example, there are consumer courts, family courts, debt recovery tribunals, and many other different tribunals and courts. So, such matters, despite of being of civil nature, cannot be tried by the civil courts due to the barring of civil courts in trying such matters. The civil courts of India have the power to try all civil matters except suits which are expressly or impliedly barred. Civil court has two conditions based on which they can decide whether they can or cannot try that matter. The first condition is that the suit must be of civil nature. Second is that the matter must not be barred by some other law from being tried in a civil court. Suits of civil nature. All civil suits do not necessarily amount that they are also suit of civil nature. It is on the courts to decide whether a matter is of civil nature or not. In case of Bhatia Cooperative Housing Society versus B.C. Patel, the court said that the civil court has inherent power to decide its own jurisdiction. The civil codes are determined on the basis of private rights of a person. Some suits that are not of civil nature are, like religious rights, a mere dignity suits for mere dignity or honor, suits against compulsion for caste, and so on. The private rights can be explained by giving some examples related to it, which are usually handled by the code, such as right to property, right to worship, right to share in offerings, damage to civil wrongs, specific performance of contracts, damages to for breach of contracts, specific relief, restitution of conjugal rights, for rent, for wrongful dismissal of salaries. Such suits are examples of civil nature suits. Expressly or impliedly barred. Suits expressly barred. A suit barred by an enhancement for the time being in force is said to be expressly barred. A competent legislature can bar jurisdiction of civil courts with respect to a particular class of suits of civil nature. Hence, a suit is said to be expressly barred when it is prohibited by the statute for the time being in force. Suits impliedly barred. A suit barred by general principle of law is said to be impliedly barred where the statute provides a specific remedy. It deprives the person of a remedy of any other form. Similarly, even civil suits are barred from the cognizance of civil court on the ground of public policy. Example, political disputes do not come under civil courts. Coming to case laws. In Rajaram Kumar Bhargava versus Union of India, the Supreme Court set down certain important consideration for the determination of implied exclusion of civil courts jurisdiction. They are whether a right not pre-existing in common law has been created by a statute, the statute itself provided machinery for enforcing of that right. Both rights and remedies have been created in one breath. A finality is intended to be the result of the statutory proceedings. Dulabhai versus State of Madhya Pradesh. In this case was relating to deciding the powers of different authorities with the relevance of taxing statutes. That how much power does the civil court has in deciding matters related to taxing when different bodies have been established by the statutes for resolving taxing disputes such as excessive tax deduction or wrong tax deductions, rebates, etc. Coming to the next topic, joinder of defendants and the cause of action. The term cause of action refers to a set of facts or allegations that make up the grounds for filing a lawsuit. A cause of action is therefore, by its very nature, essential to a civil suit, since without a cause of action, a civil suit cannot arise. The fact that a cause of action is essential to a suit is represented in Order 2, Rule 2 of the Code, where it is stated that a plaintiff must mention the cause of action if it is to be instituted as a suit. A cause of action is said to consist of two parts: legal theory, the legal wrong the plaintiff claims to have suffered, and the remedy, the relief a court is asked to grant. Sometimes the cases arise where the facts or circumstances create multiple cause of action. Joinder of cause of action. A plaintiff may unite in the same suit several causes of action against the same defendant or the same defendants jointly, and any plaintiffs having cause of action in which they are jointly interested against the same defendant or the same defendants jointly may unite such cause of action in the same suit. Joinder of defendants. All persons may be joined in one suit as defendants where any right to relief is alleged to exist against such persons, whether jointly, severally, or in the alternative, and if the separate suits were brought against such person, any common question of law or fact would arise. Illustration: where A received injuries while riding in an omnibus belonging to B through a collision between that omnibus and a cart belonging to C. A may join B and C as defendants in one suit for damages for personal injury caused by their negligence because the injury to the plaintiff arose from the same transaction or series of transactions and the case involves common question of fact. Subodh Kumar Gupta versus Srikant Gupta. A partnership firm had its registered office in Bombay and a factory at the Mandsaur. Two partners were living in Mandsaur and one shifted to Chandigarh. An agreement was drawn up in Bhilai for dissolution of partnership and the distribution of the partnership assets. The plaintiff filed a suit in Chandigarh court for dissolution of firm and rendition of accounts, alleging that the defendants at Mandsaur had misappropriated the partnership fund and the agreement created at Bhilai was void and had to be ignored. The Supreme Court held that Chandigarh court had no jurisdiction to try the suit as no part of the cause of action arose at Chandigarh, and the mere allegation of the plaintiff that he was having a branch office at Chandigarh would not confer jurisdiction on the Chandigarh court. Joinder of parties. Any party or parties which are not joined in the suit can be joined as joinder of suit if the court deems fit, subject to the discretion. As Rule 3 of Order 2 of Code of Civil Procedure was further explained by the Honorable Supreme Court in the year 2019 in the landmark judgment of Khajimunissa versus Jakia Sultana case, the Supreme Court held that this case was most appropriate case where the provisions of the Code of Civil Procedure 1908 under Rule 3 of Order 2, which revolves around the joinder's cause of action, as the court has merged the two cases having the same facts and issues by taking the suo motu action, as both the cases fully attribute and satisfy the Rule 3 of Order 2 of the Code of Civil Procedure. The view of the Supreme Court has been recognized by the various high courts all over the country. Coming to the next topic, written statement, set-off and counterclaim. The written statement is dealt in Order 8. It is a pleading of the defendant in the answer of the plaint led by the plaintiff against him. It is a reply statement of the defendant in a suit specifically denying the allegations made against him by the plaintiff in his plaint. A written statement may be filed by the defendant or by his duly authorized agent. In the case of more than one defendants, the common written statement led by them must be signed by all of them. The time limit for filing a written statement is within the 30 days from the service of the summons on him. The said period, however, can be extended up to 90 days. A defendant should present a written statement of his defense in the said period. Defenses in the written statement. In a written statement, the defendant can specifically deny the allegations made in the plaint by the plaintiff against him. Besides this, he also can claim to set off any sum of money payable by the plaintiff to him as a counter defense. Delay in written statement. If the defendant fails to present his written statement within the time permitted or relaxed by the court will pronounce the judgment against him and pass such order in relation to the suit as it thinks fit, and a decree will be drawn up according to the said judgment. No pleading after the written statement of the defendant other than by way of defense to set off or counterclaim can be filed. Coming to set off. Set off applies only and only to many matters. Set off is always defense. A claims B must pay him 10,000 rupees. B takes the defense of set-off, stating that in an independent earlier transaction, A owes B 9,000 rupees. Therefore, B takes claim that only 1,000 rupees is to be paid by him. Thus, that 9,000 must be set off in 10,000 and only 1,000 is owed. Categories of set-off are legal and equitable set-offs. The landmark judgment regarding the definition of set-off is given in Rajni Rani versus Khairati Lal. Basic features of set-off. The suit is for the recovery of money. The sum of money must be ascertained. Such sum must be legally recoverable. It must be recoverable by the defendant or by all the defendants, if not more than one. It must be recoverable by the defendant from the plaintiffs. It must not exceed the peculiar jurisdiction of the court in which the suit is brought. Both the parties must fill in the defendant's claim to set off the same character as they fill in the plaintiff's. Coming to counterclaim. The Rule 6A to 6G of Order 8 deals with counterclaim. It is the claim made by the defendant in a suit against the plaintiff. It is a claim independent of and separable from the plaintiff's claim, which can be enforced by a cross-section. The counterclaim can be set up in respect of action accruing to the defendant either before or after the filing of the suit, but before the defendant has delivered his defense or before the time fixed for delivery of his defense has expired. Such claim should not exceed the pecuniary limits of the jurisdiction of this concerned court. The counterclaim is to be treated as a plaint, and the plaintiff can file a written statement to answer it. The counterclaim can be filed after filing of the written statement. Setting up of counterclaim. A counterclaim may be set up by a defendant against a plaintiff in respect of cause of action arising either before or after filing the suit, provided such claim is not barred by limitation. In case of Munshi Ram versus Radhakrishnan, it is given that the set-off is a statutory defense to plaintiff's claim. Counterclaim is cross-action. Set-off must be for an ascertained sum of money or must arise out of same transaction. Counterclaim need not arise out of same transaction. Coming to the next topic, pleadings. Pleadings is the foundation of litigation. Pleadings has been dealt with in Order 6 of CPC. Order 6, Rule 1 of CPC defines the pleadings as plaint or written statements. The pleadings are specific documents filed by the parties in lawsuit which states the position of the parties in the litigation. Pleadings can be regarded as the backbone of any judicial system. They are documents which contain the claims and counterclaims of the parties, giving the opposing parties an idea of what case they are to answer. The objects of pleading are that there are four objects of pleading. That pleadings ascertain the actual issues between the parties and the issues to avoid surprise to the other party, and the pleadings narrow down the area of conflict. The pleadings state the facts which need to be proved at the trial. Rules of pleadings. The four words which can crisply summarize the rule of pleading is plead facts, not law. The counsel of both the parties should only project the facts in their respective case rather than suggesting on the laws applicable in particular case. To gain a crystal clear understanding of the same, the rules can be studied in two parts, that is, basic or fundamental rules, particulars or other rules. The basic rules of pleading are given in Order 6, Rule 2 of the Civil Procedure Code. They are as follows. Pleading should state the facts. The facts should be material facts. The pleading should not state the evidence. The facts stated in the pleading should be in a concise form. The particular or other rules of pleading are they have been given under Rule 4 to 18 of Order 6 of CPC. Every pleading must be signed by the party of or his pleader. Particulars with the date should be stated. Wherever misrepresentation, fraud, breach of trust, willful default, or undue influence is pleaded in the pleading, the effect or contents of the document shall be stated briefly. Coming to case laws on pleadings. All India reported versus R.D. Datar. In this case, the court ruled that certain defects in the signature, presentation, and verification of the pleading had been corrected at subsequent stages in the trial. In case of R. Patil versus K.S. Patil, the Supreme Court ruled that all amendments which satisfy the two conditions, not working the injustice on the opposing party and being necessary to provide answers to the major questions in the suit, should be permitted. Coming to the next topic, summons. To follow the principle of natural justice, when a plaintiff files a suit, the defendant must be notified that a lawsuit has been filed against him and that he must appear in court to defend himself. The word summons had not been defined in CPC. The intimation sent to the defendant by the court is known as summons. Order 5 and Section 27 to 29 of CPC deal with summons under civil litigation. Objective of summons. The following are objectives of summons. It is important to inform a person about any legal action that has been taken against him. It gives an opportunity to the defendant to present his case and side of the story. The basis of summons lies in the maxim adi alteram partem, which means to hear on both sides. It further helps in following principles of natural justice and ensures fair proceedings and trial. It helps in ensuring the presence of either a witness or accused or any other person who is involved directly or indirectly in a suit before the court to produce the necessary documents. Essentials of summon. The essentials of summon are given under Order 5, Rule 1 and 2 of the Code. These are: every summon must be signed by the judge or any other officer who he appoints to do so on his behalf. It must be sealed properly. The court will not issue any summons to the defendant if he has appeared before the court at the time of the institution of the plaint. Another essential element of summons is that every summon must be accompanied by a copy of plaint. The format of a summons must be according to the prescribed form given in Appendix B of first schedule under the code. Contents of the summons. The Rule 5 to Rule 8 of Order 5 under the code gives the content of the summons. A summon must contain information whether it is issued for settlement of issues or final disposal of the suit. According to Rule 5, the court of small causes can only issue the summons for the final disposal of a suit and nothing else. It must contain the date and day fixed for the appearance of the defendant, considering the factors like residence of the defendant, time, etc., so that he can get a reasonable time and opportunity to appear before the court. It also contains the list of necessary documents that a defendant is required to produce in court. If the summons is issued for final disposal, it must direct the defendant to produce witnesses on his behalf to support his side. Summons to defendants. According to Rule 1 of the order, whenever a lawsuit is instituted by a plaintiff, the defendant has to file a written statement within 30 days of the issuance of the summons to him. If he fails to do so and furnishes an appropriate reason, the court, after due consideration, may extend the time up to 90 days. Section 27 of the Code further provides that a summons must be issued to the defendant when the court is instituted to appear before the court and answer the plaint in the form of written statements. Section 28 mentions the condition where the summons issued to a defendant has to be sent to a different state of jurisdiction where he resides. In such situation, the court will send the summons to the court having jurisdiction in that particular area, and then the said court will perform duties as if the summons had been issued by it. Exemption from appearance when summons are issued. Section 132 provides that any woman who cannot be compelled to appear in public due to the customs and other manners followed will not be asked to appear before the court. Section 133 further gives the list of particular people who are exempted from appearing before the court personally. This includes President of India, Vice President, Speaker of the House, Union Ministers, Supreme Court judges, governors of states and union territories, speakers of state legislative assemblies, chairmen of the state legislative council, states ministers, high court judges, and any person on whom Section 87B is applicable. Case laws on summon. Objection to summon. In the case of Bherulal versus Shantilal, the court held that if there are any objections to the summons served, they must be raised as soon as possible and at the earliest. If it is not done at that stage, then the court assumes that the defendant has waived off his opportunity. Refusal to summon. Puvada Venkateswara Rao versus Chidamana Venkata. In this case, it is mentioned that according to Rule 9 of the order, if the defendant refuses to accept the summons, it is deemed that the summons has been served on him. Similarly, when he or his agent refuses to sign the acknowledgement, the court will assume that he has refused to take the delivery of summons and treat such summons as duly served. Coming to the next topic, ex parte decree. An ex parte decree is a decree passed against a defendant in absentia, despite service of summons, where on the date of hearing only plaintiff does and a defendant does not appear, the court may hear the suit ex parte and pass a decree against the defendant. The legal validity, enforceability, and operation of such decree is similar to any bi-party decree. Order 9 of the Civil Procedure Code deals with the appearance and non-appearance of the party. Define knowing definition of ex parte decree. First, we should know about the definition of decree. A decree is an official order issued by the court and it is only passed in civil suits under Section 2, Subclass 2 of CPC. In a civil suit, a decree is a formal expression of the decision made by the court that determines the rights and obligations of the party. Ex parte decree is when, during the proceedings of a civil suit, a plaintiff was present and the defendant was not present and the summons was issued. Then the court could proceed against the defendant and pass an ex parte decree. The court has jurisdiction to pass ex parte decree order, under Order 9, Rule 6 of the CPC. Application under Order 9, Rule 13 of CPC is a defendant can make an application under this order because the summons had not been served properly and he had sufficient grounds for the non-appearance before the court. The defendant has a 30 days time period to apply, setting aside the suit. Setting aside ex parte decree. The court only sets aside the ex decree when the defendant presents a satisfactory reason in the court or the summons is not served well. In case of summons duly not served well, where the suit is filed in the court, from filing the date to the suit of the suit to 30 days afterwards, the summons must be served to the defendant. But there are certain scenarios, such as postal address being incorrect or changed, where the plaintiff has not paid the fees. When the summons is not served properly to the defendant or the defendant does not get enough time to appear before the court, then the court may set aside the ex parte decree. Sufficient cause. The term sufficient cause is not defined in the court. The court will determine through its interpretation in different cases. The defendant has a burden of proof to prove sufficient cause for non-appearance in court. Remedies against ex parte decree. The civil code provides remedies that a defendant can use to set aside the decree passed by the court and get the opportunity to represent his case. A defendant against whom the ex parte decree has been issued has the following remedies: set aside, applying to the court which has passed such decree to set aside the decree; appeal, preferring an appeal against the decree; review, applying for revision; and fraud, suit on fraudulent grounds. All the remedies are concurrent and can be prosecuted concurrently. Coming to case laws. In Chotalal Mohanlal versus Ambalal Hargovan, the Bombay High Court stated if the party came late and the decree had been passed, then the party was entitled to restore his suit after paying the cost of the court. In Subodh Kumar versus Shamim Ahmad, the Supreme Court held that if the defendant proves that the summons had not been served properly, then the court could set aside the ex parte decree passed against all defendants. Vishwabandhu versus Sri Krishna. In this case, the defendant refused to accept the summons, an ex parte decree was passed, and the court proceeding was initiated against him. The suit property was put up for auction in which the appellant was the bidder. Later on, the defendant applied to Order 9, Rule 13 of CPC. The Supreme Court held that if the defendant or duly assigned person refused to take any postal article containing summons, it would be considered that the summons was duly served. Hence, the application was not allowed under Order 9, Rule 13. Coming to the next topic, interpleader suit. Not every suit which is civil in nature follows the same course of trial and proceeding. A few civil cases do not follow the regular course and are comparatively different in nature in terms of the parties and their involvement in the suit. One such kind of suit is the interpleader suit. In the interpleader suits, the dispute is between the two defendants who fight for the claim over a particular good, debt, or chattel. When the plaintiff, on the behalf of the claimant, filed a suit for choosing the actual owner of property, then it is called an interpleader suit. When a plaintiff is not in the direct possession of the property or thing he files a suit, there is more than one defendant in this suit. When the actual owner of the property dies without transferring the property to anyone, then the property transfer becomes the interpleader suit. Interpreter suit in CPC is defined in section 88 with the order number 35. An interpreter suit means if any person claims any property of her husband or her parents, and in case the owner of the property is dead without transferring the property, then the second owner has to claim the property from the bank or authority. After claiming such property, the bank or the authority has to file an interpreter suit in the court. Then the court will decide who will be the main owner of the property. In an interpreter suit, there were many defendants to claim the property. The plaintiff gets the monetary value for filing the suit in the court on behalf of the defendant. He is not liable for any damage. Essential conditions in interpreter suit are: for an interpreter suit to be filed, there are certain essential conditions which should be fulfilled. The same thing, debt or duty, must be claimed by both or all the parties against whom the relief is demanded. The person asking the relief must not have or claim any interest in the subject matter. According to Rule 4, Order 35, the plaintiff may either be discharged of all his liabilities or may be retained till the suit has been disposed. For an interpreter suit to be maintainable before the court of law, the plaintiff should not have any interest in the subject matter of the suit. Coming to case laws. Satyanarayan versus District Judge. The petitioner has filed a suit against the respondent, but the case gets dismissed by the civil judge. Then the third petitioner has filed a case against petitioner to recover the rent along with the profit. He filed an interpleader suit. In the judgment of this case, the judge dismissed the application of the petitioner under Order 35, Rule 5 of CPC. In case of Om Prakash Kapoor versus Nirmala Devi, the ownership over the rented property was claimed by the deceased nephew and a lady who had purchased the said property from the deceased wife. The court held that the tenant in this case was entitled to know to which of the two parties rent was to be paid, and hence the suit filed by him should be maintainable. Thank you. Please like, share and subscribe.